gentlemen, welcome back to the People's Law School. I want you to know we bring the best lawyers in America. Perry Shuttlesworth, our next speaker, is fixing to be one of them. I know it because he is setting records down from Birmingham up here to the Huntsville area. I'm proud to know him. I was jealous that last year I know he got a $5 million trucking verdict down here in Blount County, which is, you know what, one county away from us. And I felt like it was my case. But I salute Perry. He does that. He's gotten several multi-million-dollar verdicts, and I'm proud of him because he's from Birmingham, but he went on to the University of Alabama where he got his degree in corporate finance, and he went back to Birmingham where they hire all the silk stocking law firms, hire the very best, and so he became what is known as a transactional lawyer, and that is they just sit there and make money all day long for their corporate clients. But Perry, quite frankly, he beats to a different drum. And as you can see, he's done so many things for so many children, the underprivileged, and so many folks like that in the Birmingham and other areas that he decided to strike out on his own, and now he's running a very successful law firm there in Birmingham, and I'm proud to know him. I will tell you, while in the University of Alabama, he was the capstone man and president of the Jasons. That's as high as you can go. And also, I did not know that he is a member of the Georgia Bar, which now that if any of you lawyers looking at this sometime need a real lawyer to maybe help you in Atlanta or something, maybe Perry can do it for you. But he and his wife, Margaret, have 2 daughters, and they're very active in the Big Sisters and Big Brothers program, and they work on the housing programs there in Birmingham and do so much for our society. But the one thing I'll tell you he does is he's a magnificent trial lawyer, and I'm proud to call him my friend, Mr. Perry Shuttlesworth.
Thank you, Alan. Good evening. Appreciate y'all being here. I'm going to talk about nursing home law this evening, which I've done, I guess, 5 times or 4 times in the past. And the first time Alan asked me to do this, I talked about trucking law, trucking litigation. That's something I've done a lot of in my career. And Alan kindly mentioned, in the interest of shameless self-promotion, a $5 million trucking verdict that I had last year. And I can use that to segue into some of the things that I want to talk about with y'all this evening. The trucking industry is like the nursing home industry in the sense that both are regulated industries, okay? And that's important because there are a lot of industries out there that we deal with in the world of litigation that aren't regulated. When you have an industry who is involved in an activity where they could touch on public safety, that's typically where you see the regulations come in, okay? In the world of trucking, you've got the Federal Motor Carrier Safety Regulations, which all commercial carriers have to comply with in their operations. And the case that I had last year, which went to trial, involved a failure of a company out of Fort Lauderdale to take the advice or the directive of their maintenance department and fix a broken truck. Instead, they put it on the highways, knowing that it was likely to break down, which it did, and it caused the death of a 24-year-old girl and mother of 2 babies. And that's ultimately what led to the verdict that Alan was mentioning. Similarly, in nursing home litigation, we have federal regulations and state regulations that regulate what nursing facilities must do for the residents that they agree to take care of for profit. And similarly, if they fail to do those things, bad things happen. People die. People suffer terrible injuries, and people can die. And it's unfortunate, but that type of situation is what my firm is involved in every day in the nursing home litigation area, which is a situation where a nursing facility fails to properly take care of the folks that they're charged to take care of, and as a result, these people suffer terrible injuries. Unfortunately, in the world of nursing homes, most of the people there are elderly, obviously. They have medical conditions where they need treatment and care that's specific to their medical needs. And when they're not cared for properly and they suffer an injury because of the condition that they're in to begin with, which is that of vulnerability, they often die. And so the majority of the cases that we handle are wrongful death cases. It's tragic, but that's the reality of nursing home litigation. One thing that I'll say about cases involving regulated industries is this. They're complicated, they're labor intensive, and they're expensive, okay? When you have a case against a nursing facility, it comes under the Alabama Medical Liability Act in Alabama. And there are lots of requirements that you have to meet in prosecuting that lawsuit. You have to hire experts and submit expert testimony that they breach the standard of care. You have to have a nurse say that a nurse similarly situated, acting reasonably and meeting her obligations would have done something differently. We have to have causation testimony from physicians who testify that these breaches of the standard, the negligence, the failure to care for these people is what caused the injury or caused the death. So, you know, you have to be in a position to put the time in, to invest the money, and you have to have the knowledge, a lot of knowledge of federal regulations and state regulations to properly handle these cases. I'll say this as an aside because this is an issue in my world these days. Lawyers are businessmen like any other business to an extent. We have to make a living, we have children to feed, we have to run a business. So marketing by lawyers is something that you see more and more of, and it's okay if it's done properly, tastefully, which is not always the case. But here's what I want to briefly mention before I move on. These days there is a lot of saturation marketing on TV by injury lawyers, the ubiquitous injury lawyer, okay? And what, practically speaking, this is the effect that that's had on our world. You've got these people who are typically more equipped to do automobile accident cases, simple cases. Well, people call them for nursing home cases. They say that they can handle this case. They take it and treat it like an automobile accident case, but instead of investing the time and the money and having the expertise and going to try the case, they'll settle it on the cheap, which means that guys like us who go and litigate these cases have to come up against these insurance adjusters and lawyers on the defense side, and they say, well, your case is only worth $100,000. And of course, you know, my response is, where do you come up with that? And they'll say that's typically what they have to pay. And the reality of it is, when that happens, you know, we have to work twice as hard, we have to invest twice as much money, because some people out there handle these cases that really shouldn't. So I say that because if you ever have the misfortune of having to hire a lawyer to represent you in one of these cases, make sure that they do this type of work. You know, make sure that they've tried cases in this world of nursing home litigation. Not everybody does it. They're not easy cases. Make sure that you get with somebody who knows what they're doing, okay? All right. Another reason that we briefly mentioned this verdict from last year is this. We have arbitration provisions in most nursing home admission agreements. Now, do y'all know what arbitration is, generally? okay? I think most people have a basic idea. It is when you contract the right to a trial by jury away in an agreement, okay? And so when you enter into a nursing home or when your loved one does, you're asked to sign a bunch of documents, 50 or 60 documents often, and one of those is typically an arbitration agreement, okay? And most people really don't understand what the ultimate effect of that is or how that really affects them. And I brought with me an arbitration agreement that's in a case that I have right now. And the agreement says, what is arbitration? And it goes on to say, arbitration is a cost-effective and time-saving method of resolving disputes without involving the court, okay? Well, that sounds okay, doesn't it? I mean, there's nothing there that sounds too bad. But the problem is, that's really not the deal. That's what these things say. The deal is this. Arbitration was intended to be used between parties of equal sophistication, where everyone has their lawyer, everyone is on equal footing, and no one is superior in a position of superior power to the other, okay? In a consumer contract where it's you in the nursing home, you're absolutely not in the same position, okay? And unfortunately, our courts have upheld these agreements in consumer contracts like nursing home agreements. I want to ask you this. If this agreement that I just read said, if you sign this and through our neglect, your loved one dies, and if you make a claim against us for that, your claim will be worth maybe 50% of what it would be worth in a jury trial. How many of you would want to sign that agreement? Nobody would, okay? And that's what they should say. Really, if there's a meeting of the minds in these agreements, that's what they should say, because that's what they're used for. There is no good reason for these agreements except to save the nursing home industry money when they have claims. That's the sole purpose of these things. And you are not told that when you enter someone into a nursing home, okay? Now, in arbitration, we can still get good results, but we are behind the 8 ball. You know, we have to try and find good arbitrators, and there are many good ones, but the defense lawyers don't want to use them. They want to use one of their stable of arbitrators who are going to help them out and are going to give them a favorable result, okay? And so we fight tooth and nail when we're in that situation to try and get a good arbitrator. They're out there, but it's a real challenge. So I would say this. Yes?
But when you put a loved one in a nursing home, you hate to select a nursing home that doesn't have an arbitration clause. And you're always afraid that they all have arbitration clauses. So what do? I mean, when you're going in, it's a common practice to make you sign arbitration.
Well, the question is, what do you do, because it's a common practice, right? What you can do is refuse to sign them, okay? Because technically, if you're forced to sign one, it's called an adhesion contract, and it should be voidable, okay? Many of these agreements these days say that it's not a requirement for admission. Now, they don't tell you that, but the agreement will say that. So just say no. Just say, I will not sign it. That's the answer, and you can do that, okay? Yes, sir?
Then what happens when you don't sign it?
When you don't sign it, what happens?
Yeah, do they just eliminate from your loved one being accepted into the nursing home?
No, that's my point. They're not able to make it a take it or leave it proposition because it's an adhesion contract. Now, they may try and do that, but it's not legal, okay? So you can say no. I have clients who have said no, and unfortunately for their families, we've had to go and litigate, and we end up in circuit court with a jury, okay? So it can be done. You can say no. You can refuse to do it, and technically they still have to let you enter your loved one into the facility, okay?
Get the same standard of care as everybody else then?
Oh, absolutely. That has nothing to do with the standard of care. Standard of care is what a nurse or a caregiver is required to do in their industry. So whether you've signed an agreement or not, that's totally irrelevant. You're owed the same standard as anybody else. The only thing that relates to is how a dispute with the nursing home will be resolved. Okay? The 7th Amendment to the Constitution says you have a right to trial by jury, and really and truly you should not be required to contract that away. You shouldn't even be allowed to in a consumer contract. But it is allowed by the courts, but you have the right to say no so that you can exercise your right, if you need to have your dispute heard in circuit court, where you can get a jury of your peers in the most conservative state in America to hear your case, versus an arbitrator who is getting case after case after case from the same lawyers, getting paid by the same lawyers, and helping them on the back end with favorable results, okay?
This also applies to, you go down and buy an automobile, things of this nature. So how do you break through? And I think what I'm hearing is that's the question. How do you break through this thing and say, I'm not going to do it. We're going to negotiate for the product, whether it's a nursing home product or whether it's an automobile or whatever. How do we break through that and accomplish the desired goals of both parties, really, is to buy and sell, without one saying, hey, I'm not going to sign that, the other saying, well, you're going to have to walk then. You can't.
Well, the question is, how do you break through and how do you get what you want, i.e., someone admitted to the nursing home without them saying that you have to sign it or withdrawing their agreement to take you into the nursing home, right? Right? I can't really speak to the automobile contract issue because I don't do that kind of work. I can speak to the nursing home context, and I can tell you that if you refuse, they must let you in anyway. Is that to say that they won't tell you that you can't? Maybe they will. Call me if that happens, okay? Really. But don't be bullied by these people, okay? You can say no, you don't have to sign that agreement, and your loved one can still get admitted. And if literally, call a nursing home lawyer if that happens to you, okay? The way you break through it in a bigger sense is elect Supreme Court justices who don't believe that individuals should be held hostage to arbitration agreements, okay? That's the way to do it in the broader sense. But, you know, what we see is what I was talking about, the same stable of arbitrators. I will hear the same names from the defense lawyers every time, okay? And these are guys that are going to help them out. And sometimes we've had to learn the hard way. I'll give you, I brought something else that I want to read and give you an example of what I'm talking about. Had a case, yes ma'am?
Are the arbitrators judges or attorneys?
The question is, are the arbitrators judges or attorneys? An arbitrator can be virtually anyone. Oftentimes they're lawyers. Oftentimes they are retired judges, okay? And that's typically who we deal with. And like I said, there are some really good ones. But the defense lawyers don't want to use, and really good to me means fair, okay? That's all we're looking for. They want people that the fix is in with, really. That's what they want. I had to learn the hard way about a year and a half ago in an arbitration where I represented the family of a gentleman who was a World War II veteran. He was a farmer. He was an incredibly good man who went to the State Veterans Facility in Alexander City. When he was there, these CNAs who had little or no training tried to pick him up without using a lift in violation of the policies, in violation of his care plan, and twisted his leg into a spiral comminuted fracture, which was so extreme it had to be amputated. Okay? This man suffered a lot of pain. The nurses who did it lied about what happened. They said that they tried to roll him over in bed and somehow the leg just shattered. Okay? That doesn't happen. Okay? It doesn't happen. It can't happen that way. Well, we had to try the case, and ultimately I got 2 nurses that were fired from that facility for voicing their dissatisfaction with what was happening to this man. They came and testified that these people were not telling the truth. The director of nursing conducted a bogus investigation of how it happened in a reenactment and totally ignored what Mr. Cooper said happened. They just ignored his version of the events and came up with their own story. Well, when we tried the case in arbitration, the arbitrator ultimately found that we were correct, that the nursing home employees did not tell the truth, that they tried to cover up what happened, and that their negligence caused this man to have this horrible injury and an amputation. But in awarding damages, the arbitrator, there was testimony from the medical director at the facility that there was a possibility at some point down the road that he might lose his leg anyway. Okay, a possibility. Well, that's really irrelevant. So the arbitrator wrote in his opinion this. In the first part of the opinion, what he says is that there was a possibility that existed that Mr. Cooper would lose his leg within 6 months. That's irrelevant. I got the same doctor to admit that his condition had not changed at all. This was speculation and it was self-serving. And the arbitrator says in his opinion that this was a mere possibility. By the time the arbitrator gets to the end of his opinion, he changed his mind and said that it was, the testimony was that he would likely lose the leg. Okay? This arbitrator basically put evidence in here, referred to evidence that didn't exist. It was a possibility over here, but in trying to figure out how to give us very little money, he called it a likelihood and awarded this man $62,500 for the loss of his leg. Okay? And I can tell you that that is inadequate.
Would you mention in every case the cost, like how much, if you have to hire an arbitrator, is the effect of hiring your own judge?
That's right. I mean, the arbitrator, the question was, or the comment was, mentioned the cost of arbitration. The arbitrators will typically, I guess on the average, I would say bill $10,000 in this kind of situation. We have to spend $15,000 or $20,000 to get the experts to testify and get the case ready. So by the time, we have to go do what we do, this man wasn't compensated at all for the loss of his leg, despite the fact these people violated the standard of care and then lied about it. And in arbitration, there's no appeal. So we had to live with this, and this arbitrator got away with helping out his buddies in the nursing home industry while my old fella at the nursing home sat there and suffered without his leg. Okay? Tragic outcome. This would not have happened if we were in circuit court because he would not have been the fact finder, number one, the arbitrator wouldn't have, but if there had been an order like this, the Supreme Court would have overruled or reversed this immediately. okay? Very unfair result. Needless to say, I don't agree to use that arbitrator anymore. Here's the other point I'd like to make about arbitration. We are, whether we're in circuit court or in an arbitration, the same law applies. The Alabama Medical Liability Act, and this, in most of our cases, the Wrongful Death Act, which says that if we prove that the negligence of this defendant caused this person's death, then the damages are to be in an amount sufficient to punish the wrongdoer and to deter it from happening again, to try and make it better for the next person, right? Well, I would say that when I have a jury trial, the last verdict I got in front of a jury in a nursing home death case was $1.2 million. And this is the most conservative state in the country for verdicts. Okay, Alabama is not known for its liberalism. So I would say the verdict range in these kind of cases, when we prove our case, high six figures, million, million and a half dollars. That's usually what a conservative jury feels is adequate to punish a nursing home for profit and deter them from doing it again, to make sure that they don't do this to the next person. Now, why does an arbitrator decide that $250,000 or $300,000 or $350,000 is an adequate number when a jury is going to decide that it's 3 times that? Okay? What's the reason for that? There isn't one. There isn't a reason. The reason is that the arbitrators are there typically to help the nursing homes, okay? And that's not a just outcome. That's not a just outcome. So I say this because it's an important issue in nursing home cases. Most of my cases are in arbitration, and I wish they weren't. We still have good results. We have to fight hard for them, but we get them. But I would so much prefer to deal with a jury. Yes, sir.
What kind of influence do you have in influencing who gets selected as an arbitrator? And I would have to believe after a while, if they've done arbitration before, you probably know if they're favorable or unfavorable to you.
Yeah. Yes, okay, the question is how much influence do we have in selecting an arbitrator? The agreements call for all different types of processes. Usually we try and agree on one arbitrator. If we're not able, sometimes the agreements say that it goes to one of these bodies like JAMS, an organization out of Atlanta, where they handle the arbitration and they give us a list of people to choose from, okay? Now, if we can't agree, if there's not an entity like that involved and we can't agree with the other side, which is increasingly the case, then under the federal law, it says that the judge, if we file it to begin with, let's say in Madison County, and the defense moves to compel arbitration, well, we still have a case in Madison County. It's just not here in the arbitration. But we've got a judge, and I can file a motion to have that judge, or they can, to appoint an arbitrator. So, you know, and that sometimes is the best way to go. You know, sometimes I'd rather have whoever a judge appoints than go with somebody over here that I know is in on the deal with these defense firms, okay? So that's one of the most important things we do in arbitration cases in the nursing home world is making sure as best we can to get someone who's fair. And like I said, fair to me is someone who's going to try and approximate what a jury is going to do. The measure of damages is the same. It shouldn't be a fraction of what a jury is going to do in the most conservative state in America. Yes, sir.
So as a matter of everyday practice, if you have someone going into a nursing home and the nursing home gives you this arbitration agreement, sets it in front of you, as a matter of practice, they're going to push you to the wall and make you go to court before they tell you you can come in. They're not going to just say, okay, we'll bypass this. They're going to push you all the way to make you have a case against them, are they not? Are they just going to cave in and say, okay, we won't do the arbitration agreement.
The question is, what response can you expect if you refuse to sign? Some nursing facilities may say you can't get admitted, okay? Most of them that I've dealt with understand, they have lawyers who understand adhesion contracts, and you will get your loved one will get admitted. The truth of it is they don't have that happen very often because people out there are not told that they think if you sign this, it just means it's cost effective and it's time efficient. They don't tell you that your case is worth less if something bad happens, okay? So they simply don't have it often enough that they really, typically when my clients have refused to sign it, they have been admitted anyway. Now, if nursing homes, let's say if they started having a situation where 50% of all the folks trying to get admitted were refusing, they may take a different tack, you know. They might, in that situation, try and, keep people from being admitted without their arbitration agreements. It's the biggest protection they have. Yes, sir.
Can you speak to the proponents of arbitration and what they're telling the lay people is it kind of controls the frivolous lawsuit?
The question is, what are the proponents of arbitration telling people as to why they're in contracts?
Well, why we should support arbitration because of the overwhelming frivolous lawsuits. I mean, that's what you hear.
Oh, that's what you hear. Of course it is. But, look, it gets back to, well, they tell you that the proponents of arbitration will say just what I read to you, which is it's cost effective and it's time efficient and you'll get your rights heard without bogging down the court system, that sort of thing. And there are too many lawsuits, et cetera, et cetera. The truth of it is, when there's a verdict like the one we were talking about earlier, lawyers don't hand down verdicts, okay? So everybody can demonize the trial lawyers when there's a big verdict. I didn't decide what the verdict was going to be in my last trial. A jury of Blount County people did, and this is a conservative group of people. If you see a big verdict, it's because something bad happened that shouldn't have, okay? And so all of those arguments, in my opinion, are typically propaganda. Are there abuses? Of course there are, just like there are abuses in every industry, but there are ways to deal with it. In my business, if handling a thin or, if you will, bogus lawsuit would be the dumbest thing that a lawyer can do. Putting your time and money into a case that's not valid, it's likely to get dismissed. You're almost certainly going to lose it. They're a lot less common than you would be led to believe. But that's certainly one of the things that you hear from the proponents of arbitration. Yes, sir.
Sir, a couple things about this arbitration agreement. First off, isn't it a contract of sorts? Isn't it a contract?
It's the question
under
is.
the terms of a contract, don't you have to have the signature has to be not under duress or outside influence, and doesn't the contract have to be with the person involved? In other words, Mr. Cooper, did he sign it, or did his family sign this arbitration agreement?
Okay.
So wouldn't another party of the family have a case as well?
Okay. The question is whether or not, this is an arbitration agreement constitutes a contract, and, what things have to be in place for it to be enforceable. Number one, yeah, it's a contract, so you have to have all the elements of a contract. In my opinion, that's always lacking in arbitration agreements because there is never a meeting of the minds about what it means, because they're not telling you that what it really means is that you're going to get less money, okay? That, to me, if they were required to put that in arbitration agreements, then you could make an intelligent, informed decision, and there may be a meeting of the minds. The other part of your question was, who can sign these? Does it have to be the resident versus the family member of a resident? The Alabama Supreme Court has been very liberal in that regard, and you can admit one of your loved ones into a facility and sign on their behalf, even if there's not a power of attorney, under what's called apparent authority. If they are of sound mind and you're doing this on their behalf, the courts have found that you have the authority to do that. Now, here's an interesting exception. If someone goes into a facility and there is no written power of attorney, but they have a son or a daughter signing everything for them, and the resident or the person going in has dementia, let's say they're not of sound mind, well, there's been a pretty recent decision saying, if this person's not of sound mind, you don't have the authority to act on their behalf. They don't have the capacity to give you the authority. Okay? So in that situation, arbitration agreements have been deemed invalid because the person, the resident, was not of a mental state to actually even have the ability to say, you can do this for me. Okay? So with that, I better move on to one more question. Okay.
Statistically, what are you up against when you go into arbitration? Does the 80-20 rule apply that you got a 20% probability of winning, or what's the?
Well, I mean, you know, the question is, what are your chances in arbitration? I mean, I don't take a case unless I'm 100% sure I'm going to win it. I mean, that may sound a little overconfident, but I mean,
the point is there must be a statistical something that says this is how many that have been won in arbitration and nursing homes. This is how many have been lost, regardless of your.
No, I hear you. The question is whether or not there are any statistics out there for how many cases in arbitration result in favorable awards for the plaintiff versus awards for the defendant, and the answer is no. There are no statistics about that. Okay. Now, the cases that I take, you know, I screen them extremely carefully. Before I file them, I have a physician who's a pathologist who looks at it and says, this violation of this person's or the standard of care is what caused this person's death versus some other cause of death. And I also have nursing experts who look at these and they say they absolutely breached the standard of care. So before I file a case, just for me personally, you know, I feel very confident that I'm going to win. Winning is a vague term in that context, though, because while I may get a verdict, if I don't get a verdict that I think is a fair amount to deter and punish the people who caused this person's death, then while I may have won in the sense of getting, you know, an arbitration award, to me, a win is when there is a just award, not just an award. So there's an award that approximates, in my mind, what a jury should do. I think that's the fair approach that an arbitrator should take. If they want to give somewhat of a discount, okay, but 30% of what a jury would do, there's no rational basis for that, or 40% or 50%. So, all right, that's my talk about arbitration. And before I run out of time, I want to talk a little bit about the nuts and bolts of these cases, since if for no other reason, the handout I gave you says anatomy of a nursing home case. And I have veered from that from the moment I stepped up here. So I'm going to cut to the chase and tell.
They did it to you on purpose. I will tell you, Mr. Shuttlesworth, they did it to you on purpose.
Yeah, that's okay. Well, if I can't handle that kind of effort to throw me off track, then I'm in the wrong business altogether, I assure you, and you know that. Here's the basic thing that happens in nursing homes that give rise to nursing home cases, okay? What happens is someone goes into a nursing facility because the family, they can't care for somebody, okay? People have to work. They've got to raise their own kids. They don't have the manpower or the resources to quit their jobs and care for their elderly loved ones. So, you know, they have to put their loved one in a facility, and they have a certain amount of functional ability. what we call ADLs, activities of daily living. Can they feed themselves? Okay? Can they ambulate? Can they walk? Can they transfer from a bed to a chair? Can they roll themselves over in bed to avoid pressure sores? Okay? Are they continent or are they incontinent? Those are the things that day to day we call ADLs. And when you go into a facility, a nursing facility, there are assessments done to determine what your needs are. Okay? Those needs and what needs to be done to properly care for this specific person results in a care plan that says every day this is the care that has to be given to this person. Everybody has their own individual care plan. This is when things go poorly. At some point, all of our ADLs change. Mine have changed, and I'm only 49. I mean, there are things that we can all do for ourselves now that we won't be able to in 6 months or a year, certainly at that point in life. So if someone in a facility, let's say they develop dementia and they no longer really want to or are able to eat on their own, okay? They need assistance eating. Or let's say they develop dysphagia. They can't swallow properly. They need assistance in some respect, maybe a changed diet or even tube feeding. Let's say that there's an injury that occurs to someone. They fall and injure their hip, so they can't get up on their own anymore. Okay? Well, what is supposed to happen is, and that's called a significant change in condition. And when that occurs, the nursing facility is required to notify the family and the physician, and there is supposed to be a new assessment and a new care plan, okay? So that if someone can't turn themselves anymore, you've got someone coming to turn them every 2 hours so they don't get bed sores. If someone can't feed themselves, you've got someone to assist. If that doesn't happen, I mean, it doesn't take a brilliant legal mind to know what the outcome is going to be. If someone's not able to turn themselves and the nursing staff's not doing it, you get bed sores, okay? If you're not getting the assistance you need with eating and drinking, you get malnutrition and dehydration. If you're incontinent and you're not getting good catheter care, those things cause infection. If you're incontinent and you simply need briefs, but they're not getting changed, again, urinary tract infections. Yes, ma'am, you had a question?
I just wanted to say, isn't there a much more detailed assessment also taking place that goes into the care plan, namely the minimum data set, which is pages and pages of information on this patient's health?
Yes, ma'am.
On his diagnosis, on previous operations, this,
Yes.
that, the other. So it's not just the activities of daily living.
Right.
It's the whole body that
Yes.
is being assessed.
That's right.
And the history of that.
Yeah. The question is about assessments and what we call minimum data sets or MDSs. That's a Medicare document that you're required to have one within 14 days, then within a 30-day assessment, a 60-day and a 90-day, then a quarterly and an annual, and you're supposed to have a new one when there's a change in condition, okay, or a new admission if they had to go to the hospital. So if these are very, very specific and very detailed assessments, because, you know, without that, you don't know what the person needs. So the appropriate MDS assessment is extremely important, and it deals with a lot more than ADLs, like you said. But whether it's ADLs or any other condition, you have to have the appropriate interventions for what this person needs so that their condition is maintained. And if that doesn't happen, the condition goes downhill and bad things happen. Almost without exception, some form of that is what happens in all of our cases. Okay? Example, case I had last year, gentleman had a stomach virus, okay? A basic stomach virus, gastroenteritis. If my children have a stomach virus, what do? You make sure they get fluids, right? Okay, well, this guy was not able to drink anything because he was sick to his stomach. They did nothing to assess that. They did nothing to account for that. If you looked at the records, he didn't drink anything for several days. He had dementia to begin with. Dementia residents need encouragement. They need repetitive encouragement. Instead of somebody looking at the situation, calling the doctor, saying, this is what's going on, he's not drinking, we need IV fluids, they did nothing, and he ended up at the hospital 6 days later, extremely dehydrated and in acute renal failure, and died that day. Okay? Another case I have right now, a lady fell and broke her hip and was very active, very sound mind, had a great quality of life. When she broke her hip, it was difficult for her to move around. It was painful to be repositioned. Instead of calling in the care planning team and talk about how to change this in light of her change in condition, they did none of the above. She developed a stage 4 pressure sore. They never told the family. By the time she got to the hospital, it was all the way to her bone. She developed necrotizing fasciitis, which basically just destroyed all of her tissue, and she died 2 weeks later. Okay, so you know that's what you need people in these facilities to be very. You need the director of nursing, the supervising nurses, to make sure that the people under them are paying close attention. If there's a change, it's addressed. When that doesn't happen, then people go downhill quickly and develop terrible conditions and injuries, and they often result in death. Yes, sir?
So in those 2 cases, you suing for wrongful death?
Yes. The question is, are those 2 cases wrongful death cases? Yes. One of those we've already resolved. The other is in litigation now. That's right. That's the only cause of action you've got when someone dies as a result of negligence is for wrongful death. You know, the regs talk about pressure sores. The regs, both federal and state, talk about dehydration and malnutrition. The regs talk about incontinent care or continent care. And it says very specifically, and I'll give you the example with pressure sores. The regs say that the facility must take all necessary action, and I'm paraphrasing, to make sure that anyone who enters the facility without a pressure sore does not develop one unless they're clinically unavoidable, okay? Now, I'll tell you this. In years and years and years of doing this kind of work, I have literally never seen a person who had a pressure sore that was clinically unavoidable. Now, the nursing facilities, you know, will tell the family, this just happens to old people. They just get pressure sores. We did the best we could. Or, you know, they're just going to get urinary tract infections. We did the best that we could. That is almost always untrue, okay? With pressure sores, if you get proper hydration, fluids, proper nutrition, especially protein, you turn and reposition these people, okay? You watch out for other sources of infection. You make sure if they're incontinent that they're kept dry and clean. They typically do not happen. They almost never happen. So, you know, when we see pressure sores that get infected and someone dies from septic shock, or urinary tract infections that go on and on and on, and someone gets septic shock and dies, you know, that's a huge red flag for me, because those conditions should not typically occur. You know, the defense will always say, but, you know, they'll try and play the card that they were elderly, they had lots of health problems. Well, no kidding. They're in a nursing facility, okay? You know, that's what they're in the business of handling, people who can't help themselves, all right? The cause of death that should happen with these people may be heart failure, okay? It could be is truly a natural cause of death. Dying from a horrific infected pressure sore that goes to your bone is not the outcome that should happen. It's not the way these people should spend their last days. Same with infections and same with dehydration. You'd be shocked the number of cases that I have where people die of renal failure because of severe dehydration. Just as simple as that. Pay attention. How much fluid are they taking in? They'll have they will have a dietary consultation that says they need, for example, 1,900 cc's a day. All you got to do is look and see how much they're getting. But you know what? They don't a lot of the time. And so these people, you know, who are in compromised situations, many of them have dementia, lay there and get more and more dehydrated until their kidneys fail and they die. And that's a tragedy. Yes, sir?
Well, but the other thing, talking about renal failure and dehydration, but what about the hospice situation? That's exactly what they want to happen.
You asked about hospice. Come again with a question.
The question is if that's what hospice believes in, dehydration.
Yeah, I mean,
using morphine. And
well, hospice is a term that is really a little broader than it used to be. It's not just comfort care, end-of-life care. Hospice does a lot for people who need home health care. A person can be on hospice for months and months and months. That doesn't mean that you withdraw feeding and hydration just because you have hospice coming in. Yes, ma'am, you've been trying to ask me a question.
Well, I was going to ask what he just asked. Have you ever thought of starting to litigate the cases? What I'm seeing happening with hospice now is they'll put people on pain medicine because they're terminal, but they're not having pain. But they'll put them on pain medicine, and then they won't feed them for 3 days, and they'll die.
Yeah.
And I've at least had 5 or 10 people tell me that's happened with their relatives.
Yeah.
Are you thinking about litigating that?
So the question is, in a hospice situation, have we litigated where a person gets pain medication they don't need and that causes their decline? That's something that we've, you know, is a part of the bigger picture, and we have litigated those issues, absolutely. You know, ultimately, when you litigate one of these cases, a wrongful death case, the only evidence that is admissible is the negligence that caused the death. So you have to make that causal connection between the pain medication and the death, and that can be difficult, but that is an issue that we have litigated and we always look at. So sometimes, you know, people, you often see folks getting regular pain medication who really don't need it, and it makes them easier to deal with. You know, that is why they give these pain medications, and that can be a breach of the standard of care as well, to give a person this medication just because it makes it easier for the nursing home if it's not clinically indicated. I think I'll use my last couple of minutes to say, from a practical standpoint, the things that I've seen that are the most effective ways to prevent these kind of outcomes for people in nursing homes. You know, you can choose as carefully as you can, but this is a problem that exists in almost every nursing home I see. There are a lot of good nurses out there, don't get me wrong, and there are some good facilities, but in most of these facilities, my experience is they just don't have enough nurses, okay? The things that you can do as a family member for someone in one of these facilities, you can ask a lot of questions. You know, you can ask question after question and get on somebody's nerves, demand to meet with the doctor and find out what they're doing. If you see a condition you're concerned about, what are you doing to address this? What are you doing to address the fact that they don't feed themselves as well as they used to? What are we doing to, you know, make sure that as their condition declines, which every human being's condition will, that things that the care being given is tailored to what they need. Be there as much as you can. It's difficult, but the folks who were there with their family members, those people, honestly, I think usually do get better attention. Had a lady whose family I represented 5 or 6 years ago who was a Katrina evacuee. Her family couldn't find her. When the Medicare Part A money ran out, when she was the most profitable for this first 100 days, they took good care of her. When that money ran out, they stuck her somewhere, and she died from 5 horrific stage 4 bed sores, and the Jefferson County medical examiner deemed it a homicide. Okay? She had nobody to advocate for her. So being there and making sure that they know that you're there and asking the questions is one thing you can do to help. And I'm out of time, so I appreciate very much your attention. Thank you so much. Yeah.